Our second case this morning is a motion for discretionary review, case number 61668-8, Gina Bloom versus Brian Parker.
Good morning, everyone. And counsel for Petitioner. It looks like you reserved 3 minutes for rebuttal. You can proceed when you're ready.
Thank you, Your Honor. May it please the court, Shannon Drawn on behalf of the petitioner for this matter, we are seeking that the court grant discretionary review, a question governed by the rules of appellate procedure, rules of appellate procedure 2.3b, 1 and 3. They are applicable to this case as this case presents a question of first impression for full briefing. And we are asking that the court grant discretionary review.
What's the issue of first impression?
The underlying issue for review is, does a Title 26 GAL, when appointed by a judge, therefore serve in a judge's execution of the judge's own judicial duties such that the GAL is afforded judicial public officer status for venue?
So does the statute automatically confer public officer status upon people who are helping a public officer? Or is it really that it can be either a public officer or someone helping them fulfill their duties?
It's the public officer or someone acting on behest in the duties of an extension of that public officer. The policy there being to protect the individual acting on behalf of the public officer such that they're not sued separately for what they've been doing on behalf of the public officer.
So if somebody is doing something that touches on the duties of a judge, are they acting as a public officer or are they simply helping them, and isn't that latter one sufficient?
Based on what Your Honor just asked, touching on the duties of the judge, they would be for that duty in that official capacity under that statute as a public officer.
And a judge is a public officer?
Correct. We all agree, I believe, on that, Your Honor.
And the judge in this case had to find what was going on as far as the best interests of the child.
That was the intent.
And judges throughout the state employ guardians ad litem to help them determine the best interests of the child.
Yes, in an investigatory manner.
Doesn't that touch on the duties of the judge?
No, Your Honor. The judge's duty is to determine facts, remain neutral, sign orders, manage continuances, determine findings of facts, determine motions. The judge is never to investigate a matter before him. A judge is never to go into a home and investigate a personal matter between a mom and a child or a dad and a child, or go to their work and interview their coworkers. None of those are judicial functions, Your Honor. The judicial function is completely discrete and separate from a GAL.
So you don't think, well, it sounds like you're arguing that judges are to find what's in the best interest of the child, but that the guardian ad litem is somehow not connected with the judge's duties in that regard?
Well, in so much as the duty of the judge is to look at evidence, examine that evidence, and then weigh it to determine the best interest of the child, the GAL is providing him information. But it's just like an expert witness. An expert witness doesn't automatically become an officer of the court because they give the judge information to render a decision.
But again, does the person have to become an officer of the court to qualify?
To qualify for what, Your Honor?
Under the statute.
They need to be touching the duties of the public officer at the behest of the public duty or of the officer. And here the judge didn't assign the GAL to go deliberate or rule on motions. He assigns the GAL to go investigate underlying factual information, which is not dissimilar to an expert witness that comes to the court, testifies facts, and the court takes those reports, that evidence, and weighs them. The court, if they are working through a GAL, expands the judicial powers so far beyond what's prescribed to the court that it no longer bears logic.
Doesn't Eubanks weigh against that argument, though?
I'm sorry, Your Honor, just a second. Could you please repeat your question?
Doesn't Eubanks, the case that respondents cite to from the Supreme Court, undermine that argument?
I'm sorry, Your Honor, I have the wrong reference point in my notes in front of me to give you a direct answer.
No problem.
My concern is that the court is extrapolating the duty to be fair as a duty that can be given by a judge to another party. The judge is meant to weigh evidence, not go discover it. The GAL interferes in the family, goes into the workplace, directly interviews children and witnesses. These functions are so beyond a judge that we cannot judge those actions as judicial actions that would then be afforded venue protections. What the GAL was doing was not judicial. The GAL was functioning under their own statute, their own functions and their own duties. The judge pushes play. GAL, you're assigned, now go. They're independent, they work on their own, and they report to the judge. Very different than working for the judge at the direction of the judge.
So if there wasn't a guardian ad litem,
They may have other experts.
and who would those witnesses be in this type of case?
They could be a mother, they could be a father,
Or
or a doctor,
the child, right?
maybe.
And so isn't one of the intents of having a guardian ad litem do this kind of checking on what's going on with the child to avoid the need of having the child come into court?
Maybe. It depends on the context of the question, Your Honor. I think what you're asking is whether or not that creates a public official position because they are reporting on hearsay testimony from the child. I don't think that that can be extrapolated to create a public officer position.
Well, and again, I'm not asking if it creates a public officer, but whether or not it touches on the duties of the judge.
We certainly argue no. The duty of the judge is to weigh the evidence, not gather it. Thank you, Your Honor.
All right, thank you, counsel. And counsel for respondent, you can proceed when you're ready.
Good morning, Your Honor. May it please the court, Pam DeVette for Damon Canfield and Canfield Meadow Law Group, 2 of the 4 defendants in the trial court matter and respondents here. Ms. Bloom argues that the Superior Court erred by ruling that Brian Parker was a public officer under RCW 4.12.020 sub 2, and we say that actually it's clear that the Superior Court did not make that ruling at all, and Ms. Bloom's major premise is baseless. What the Superior Court did rule is twofold, that under RCW 4.12.020 sub 2, Snohomish County is the proper venue for Brian Parker as the guardian ad litem because he's a person who, in aid of the family law judge, did something touching the duties of the family law judge. And as you were raising, Your Honor, the statute's language is not limiting. It's very broad. I'm reading from a copy of the statute now that says, a person who, by his or her command, meaning the family law judge's command, or in his or her aid, shall do anything touching the duties of such officer. It does not say specifically as to his or her role as judge on the bench. And it says anything touching the duties of such officer.
So what's the distinction under the statute between someone coming in as an expert witness, say a social worker who has expertise on child abuse, something like that, as opposed to a guardian ad litem? What's the distinction?
The distinction that I can see immediately, Your Honor, is that usually an expert witness is hired by the parties and is going to be biased, at least to some extent, in favor of the party that hired him or her. Otherwise, the party would not put that expert witness on the stand. The guardian ad litem, however, is appointed by the court and is supposed to be taking a neutral position as to who is the appropriate, what is the best interest of the child at issue. They are supposed to look into the different family situations, the different workplace situations, but that's the evidence that the court wants to find out about to determine the best interests of the child. The second finding that the Superior Court actually ruled is that under RCW 4.12.025 sub 3, Snohomish County is the proper venue for all the other defendants, including my clients, because they are located in Snohomish County and their actions related to this case occurred in Snohomish County. So the 2 questions for the Court of Appeals today are under RAP 2.3, and those are: by transferring venue to Snohomish County, did the Superior Court commit an obvious error which would render further proceedings useless? And by transferring venue to Snohomish County, did the Superior Court so far depart from the accepted and usual course of judicial proceedings as to call for a review by the appellate court? Our position is that the Superior Court's venue determination was correct as to all defendants, and that even if RCW 4.12.020 sub 2 does not apply to Brian Parker, venue is still proper in Snohomish County for all the other defendants, and changing to Snohomish County is appropriate, and this review is not necessary. The Superior Court made the correct decision to change venue to Snohomish County, and Ms. Bloom didn't carry her burden under RAP 2.3b. So we're asking the court to deny interlocutory review on this case. I do not know where Ms. Bloom came up with her statement on page 2 of her reply brief that we offer the court no analysis of these two RAP 2.3b standards. Not only did we expressly address RAP 2.3 in the brief, but we also set forth the ways that the trial judge's decision was correct procedurally and substantively. So even setting aside the old maxim that is proving a negative, I know of no better way of showing that the trial court didn't so far depart from the accepted and usual course of judicial proceedings than by showing the judge did everything according to the accepted and usual proceedings. And likewise, how better can we show that there was no obvious error than to show that there was no error at all?
So hypothetically, if venue was improper in Snohomish as to one of the defendants, what's the proper course of action at that point as to the case?
I think I heard you. Can you repeat your statement? I didn't
So
hear you.
hypothetically, let's say it's clear cut that venue is improper as to one of the defendants. But the other defendants are fine. What's the proper course of conduct at that point?
The proper determination is that if the court has discretion to transfer venue for one of the defendants, it can transfer the venue for all of the defendants. Why do we say that the judge made no errors in this case? First, let's take my clients. They reside in Snohomish County, which is a standalone basis for them to seek a change of venue to Snohomish County under RCW 4.12.025, which provides that venue is proper in the county of the defendant's residence. So even if Brian Parker had not moved for a change of venue to Snohomish County, my clients could do that. And the venue statute directs the Superior Court to change venue to the county where the action ought to have been commenced, or the most convenient county on under RCW 4.12.060. So independent of any analysis regarding the guardian ad litem, the Superior Court did not err in granting my client's request to change the venue to Snohomish County. And that same basis would support change of venue for Port Gardner Law Group, one of the other respondents in this case. And then looking at the ruling as to Brian Parker, the guardian ad litem, remember the question isn't whether the Superior Court should have ruled that Brian Parker was a public officer. That is not what happened here. The Superior Court applied the other language of RCW 4.12.020 sub 2. And that statute states that actions for causes of action shall be tried in the county where the cause or some part thereof arose against a public officer or against a person, such as a GAL, who by the judge's command or in his or her aid shall do anything touching the duties of such officer. That expansive language, that's not limiting. And for a guardian ad litem who is recognized and conceded by the petitioners to be an arm of the court and granted quasi-judicial immunity, the language in this statute, the venue statute, is in keeping with that status. The Superior Court determined that in carrying out the duties of a GAL to investigate and opine on the best interests of the children, Brian Parker was doing something in the aid of the family court judge. And the language of this statute supports such a determination, and Ms. Bloom has provided no contrary authority. So the Superior Court didn't err in granting Mr. Parker's request to change venue to Snohomish County. Ms. Bloom's actual burden under the appellate rules that she relies on, RAP 2.3b1 and 3, were not met in this briefing. Ms. Bloom's burden under RAP 2.3b1 is to demonstrate that by transferring venue to Snohomish County, the Superior Court committed an obvious error which would render further proceedings useless. She hasn't met that burden. Our Supreme Court has said subsection B1 requires a high certainty of error. That's the dependency of NG case 119 Washington 2nd 588 from 2022. Here, all the parties wanted venue transferred out of Clallam County Superior Court, every single one of them. And RCW 4...
So counsel, I'm sorry, before you run out of time, can you talk a bit about Eubanks and how it is persuasive here?
Yeah, Eubanks talks about that other part of the language in RCW 4.12.020 sub 2, which is a person specially appointed to execute his or her duties for an act done by him or her in virtue of his or her office. So in that case, and the analysis in our briefing is extensive on that case, it talks about what it means to be in virtue of someone's office, and that when you're talking about something like human resources activities, that would not be in the same category as prosecutorial authority. So a prosecutor is a public officer, and prosecutorial actions are done by him or her in virtue of his or her office, but the sexual harassment was not. Similarly here, the guardian ad litem was doing things having to do with the statutory list of duties that the guardian ad litem has. That's the legislature's decision about what the GAL should be doing. And the court is required to find the best interests of the children. So those are exactly in parallel, sort of like the prosecutorial duties would be the prosecutor's duties. Your Honor, in short, we would ask that the court not take up this case on review. Thank you.
All right. Thank you, counsel. And counsel for petitioner will reset the clock, and you can proceed when you're ready.
Thank you, Your Honor. For the record, my name is Rasham Nassar, and I'm co-counsel on this case for plaintiff petitioner Ms. Bloom. I want to begin with Eubanks. Eubanks involved a deputy prosecutor. That deputy prosecutor was already classified as a public officer. For purposes of that case, what that case did was it narrowed the definition of public officer for an individual who was already labeled one to exclude acts of misconduct that were not performed in the duty of his or her role as a public officer. We don't have public officer status here, so that case is entirely distinguishable from the facts in this case. And in our opinion, in our briefing, we distinguish it.
Then you concede that the matter here is not whether or not the gal is a public officer.
Public officer or acting in the performance of the duties or carrying out the duties of a public officer is our contention.
That's the key issue here, is that second part of that.
Yes, but my point was that Eubanks involved a public officer and it narrowed the application of public officer status. We don't have that here. So it's not applicable in our case, and if anything, we feel that it supports our case.
So do you agree with counsel's statement that if it's proper venue for one of multiple defendants, then the judge has discretion to make it the proper venue for all defendants?
I think that's a premature question. Venue is the choice of the plaintiff, and that's well established in Washington case law. So plaintiff has the right to choose venue. In this case, plaintiff chose proper venue, and for reasons that we iterated in our briefing, I won't repeat, filed a motion to change venue. The triggering legal question that the court answered to favor defendant's choice of venue is the issue of the GAL. That issue has not been answered yet. There's no controlling authority that affirmatively can affirm what the trial court decided in that case to favor defendant's choice of venue. So we have to start again with plaintiff's choice of venue. And if we get a decision from this court, again, we're here on discretionary review. Clearly this issue is litigatable. There's argument to be weighed on both sides, and there's case law out there that supports, in our opinion, our interpretation of the rule to not include Title 26 GALs.
So none of what you just said, though, is the standard for B1. Right? It doesn't matter that it's an issue that is debatable on both sides and that it could be litigated fairly and reasonably. That's not B1. B1 needs an obvious error.
And venue decisions are granted often a discretionary review under B1. And the reason is because if we allow the case to be litigated in a venue that is improper, meaning that the venue has no jurisdiction because it was improper from the start, then that renders the entire case useless. Any final decision rendered in this case from the Snohomish County Superior Court when it goes to final appeal, will include the appeal of this interlocutory ruling transferring venue to Snohomish County in the first place, because it was never improper. That's RAP 2.3B1. That's why discretionary review is entirely appropriate for interlocutory venue decisions. I think more cases are granted discretionary review for decisions involving venue than otherwise.
All right, thank you, counsel. The matter will be taken under advisement and a ruling will be issued shortly. Thank you.
All rise. Court is now in recess.